Finally, the time has come. You no longer have to choose between conventional medicine and alternative medicine. Today, unlike years past, your team of doctors from all disciplines are working together side by side for the benefit of you, the patient, to help you regain your health and cross the bridge.
Welcome to Legal Straight Talk. I'm Brett Harrison from the Harrison Law Group. Today we have a special guest, a friend of mine, an attorney out of Woodbury, Don Hochler. Don, thanks for coming today.
My pleasure.
Today is going to be an interesting one. I like to call this one, for the business, 50 Shades of Getting Paid. Okay, so Don, with that introduction, I'd like to talk about, a lot of times people say, small businesses, they don't have in-house lawyers because they're expensive. They're not a big company. But you know what? From business to business, sometimes they have to collect their money to maintain their business. They have to get paid. They have receivables. And a lot of times they say, you know what? It's so hard I can make the sale, but then trying to get paid is another issue. So Don, I know you have a lot of experience, but this one is kind of an interesting one because we're saying, what can we do in-house prior to hiring the attorneys, prior to hiring a gentleman like yourself or another firm? How can we talk about how to prevent hiring Don or another attorney? What can you do in-house?
I have the rest of the public prevented from hiring Don. But what's very important is your upfront work. Whatever you do early on is, if you're doing business with a business, have them fill out an information sheet. Very often businesses have salespeople, and they get paid commission, but they may get it in advanced. They're not as concerned with the actual collection. So you have to really make it incentive-based. If they're going to be paid, they should be paid.
Now you're talking about your employees.
I'm talking about your employees, so I'm talking about how you set it up. And the reason being, their initial intake information. You want to get credit information. You want to get a bank. You want to get people they've done business with and possibly do a credit check. The reason being, if you start a lawsuit, you're permitted to levy on the assets of the defendant, the customer who didn't pay you, and also any third-party vendors that they may do business with.
You're allowed to collect from those vendors?
You're allowed, what you do is you serve an information subpoena and restraining notice after you get a judgment on the merits. And instead of paying the debtor, your customer, they're required to pay you.
Okay, but let's take a step back. Let's start with where you said, when you have your sales force.
Right.
And you're saying, before your sales force goes out and if they have a potential sale, that information that they get on their prospective new client, what information specifically do you want? And where would you go to check to see, the information?
Well, there are credit checks that you're permitted to take.
Which are?
Well, what you're able to do, you have to be careful. There's consumer debt, which is and there's business to business.
Let's talk about business to business.
Okay. Well, you want the banking information, where they bank. You want to know some of their larger customers. And they may not be willing to give you that, but they should give you the banking information. It's also important to know the correct legal composition of the entity. If it's a corp, if it's an Inc., if it's an LLC, if it's a sole proprietorship. That's very important.
Well, now, it's called legal straight talk because we try to take the legalese and put it into plain English.
Okay.
So let's, in a very simplified manner, when you talked about the LLC, the Inc., the partnership, go to a few minor differences that you automatically think about if you're, advising a business.
Okay, well, it's very important to get the correct legal composition. If you have to start a lawsuit and you proceed against the wrong party, you're not going to be able to collect. And what will happen is you sue them, you get a judgment, you send the sheriff or marshal, and the marshal or sheriff goes there, and it turns out it's the wrong entity.
So you wasted time, money, and effort.
Right? And also, yesterday's receivables, a receivable is like fruit. You want to collect it when it's fresh, because the longer you wait, the entity may go out of business, or their money's going someplace else. And your cash flow is very important.
That's how you survive. I mean, you can make all the sales, and like you said, when you have a salesperson that works for you, a lot of sales get, as soon as they get the sale, a lot of these owners pay them a percentage. So you're recommending how should they maybe structure that? What's an idea that you've seen that you think is a popular and a smart from a business perspective?
Well, I think there has to be some inherent delay. There could be a draw against commission, but they shouldn't get their whole commission until you're able to collect. Then there's an incentive for them to do a little more due diligence to make sure they have the right information and to make sure it's a good customer.
Because you know what you see a lot of times, some of these people that are in sales, they make a lot of sales, get their money, and then a couple of months later they move on. But now you're left holding the bag as the employer.
Well, it's interesting you mentioned that. I know in the brokerage industry, for instance,
right?
They sign an agreement, and if the money is not good, it's a draw against future receivables. They have to pay that money back. In other words, if you pay them $3,000 a week, and then it turns out the money not to be collectible, they are required to return whatever that percentage is to you.
But, I mean, do you have a lot of legal recourse if they leave before they have to return it?
Absolutely. You have a written document.
Well, you haven't actually signed a contract.
Absolutely. And again, let's be realistic about it. A lot of small businesses are not going to do that. That's more of a bigger business with, bigger margin, bigger sales. But I would impress upon my employee when I hire him how important it is to get the correct information and to really vet and to do due diligence on the collectability of the customer.
Now, when businesses are setting up a new customer or a new business that they do sales with and so forth, is there certain guidelines that you try to recommend how long they should structure the receivable? Should it be 30 days out, 60, net 90, net 120? Is there a general rule?
There's no general rule. With me, it's a matter of feeling. It's a matter of gut. I think what you have to do is you have to size up the customer.
Okay.
Where did the customer come from? Did it come from a good customer? Did they contact you? And you get a feeling.
Well, you also have to size up the industry.
Right.
Sometimes in the industry it's net 90, net 60. But I've also seen it where some businesses say, well, if you pay us within 30 days, we'll give you 10% off.
Right.
60, if you pay us on cash on delivery or when you take it, well, then we'll charge you 7% less, 10% less.
Well, if you're going to extend credit to an unknown entity that's not in business, I would ask for a personal guarantee on the initial intake information. If this person doesn't have a track record, I want a personal guarantee. And again, they may balk at it, but it's always good to ask for it. And then you have to make a decision, do I want this guy's business? You need the business, but you need good business.
Right, because the more time you spend on bad businesses means you're not the opportunity cost lost to actually procuring new business that actually pays.
Right.
Now, with personal guarantees, do you find that's what industries do you find that you work with that there are many personal guarantees?
Well,
that's typical?
I'm doing collection work for 34 years, and the personal guarantee is a very effective weapon. Because a business can always go out of business. ABC Inc., it's out of business. It opens up under another name. And then to try to link the two business entities is expensive and difficult. However, if you have a personal guarantee, you can always go against the individual. And if you have a personal guarantee and you sue them, and
Right.
you're able to get a judgment on the merits, You file a transcript. Anytime, if they own real property, you can levy on, you can't have the property sold, generally speaking, but it's a lien on the property when they do sell it.
Or if they try to get another, let's say, a bank loan,
Right.
refinance, that's gonna, as long as it's filed properly,
Right.
that's gonna pop up, and then there's a standard amount of interest, is there not?
Well, the legal rate of interest, interestingly enough, is 9%. It's been 9% since I've been an attorney, which is 1982. And in today's market, you know, a lot of businesses, I'm in the medical field as well, and some of the medical providers, the court dates are stretched out 3 and 4 years. And if they have a good case, they're happy to earn 9% on their money. The way it works with interest is you're permitted to sue for the contractual rate or the legal rate. Contractual rate, very often I have represented banks, maybe up to 24%.
And they're allowed, if you contract with that to be that high?
You put it in your complaint. Very often courts, particularly in the city of New York, will not allow the contractual rate. But it's always good to sue for that amount because that's a negotiation point.
It gets the ball rolling to resolve it.
Well, it gets the ball rolling if you're going to be able to settle it. They feel like they're getting something.
Right.
And my big tenet and feel about collections is you really never want to put a person in a corner. You want to try to work with them if you can while protecting your client, okay? And if you're going to collect or settle with them, you want the first number to come from them. You don't want to bid against yourself.
Now, when you're dealing with the billing department, if you have your own business and you have one person or a secretary or somebody else that deals with trying to collect, how do you recommend they go about it? Do they contact in writing, via mail, email, regular mail? Should they do it every 30 days, 60, 90? Without being too much in somebody's face, but at the same time, you have a business to run too, and it's based upon, you know, the collection of receivables.
Well, again, as far as being in someone's face, it's all in the approach. I think it's very important, depending on the size of your business, that the owner of the business does not make the collection calls. I think you have someone assigned to it, someone who's very pleasant, and the first call that you make is on an informational basis.
Meaning what?
Hi, Mr. Harrison. I'm calling on behalf of ABC Industries. You may not be aware, but we have an outstanding balance of $1,000. And then you listen. Less is always more in the collection.
So the first thing, you don't say, when am I going to get paid? When can you?
No, you don't want to make it confrontational.
You don't want to be aggressive.
You know, well, there's always a time for it.
Right now.
But most people don't pay because they don't have the money. They got divorced. They got sick. Businesses down. Most people's business model is not to try to beat the vendor. Okay? So you want the first call absolutely to be very pleasant and informational. You may not be aware, but we have an outstanding balance. And then just listen. Oh, it slipped my mind that they were going to write the check. That's fine. And then what you do is you advance the ball. How can I get paid today? And then again, you listen. I don't have the money now. I'll give you a post-dated check. I'll give you in 30 days. Really, Mr. Harrison, I need something today. What can you get me today? I'm willing to work with you. I'm willing to show good faith with you. Show some good faith with me. Again, what you want to do is humanize the situation, but you don't let them off the hook. In addition, you mentioned the written communication.
Well, now that's a phone call.
Right.
At what point do you follow that up with writing, or do you just, when is that next phase?
Okay, it's very important. And again, as an attorney, we very often we have billable hours. And very honestly, it's a pain in the neck to fill out your timesheets. It's very important that you stress to your employees those bills must go out at the end of the month or the first day of the month. Because any delay, it's money out of your pocket. So you send out the first of the month, the bill goes out. And you have maybe...
Is there certain language that you would recommend? Again, probably not being aggressive, but...
No, honestly, the concept of... I'll get to that. So you're sending out the bill January 1st, and you don't get paid. And you have terms in there, if they pay, within 10 days or 20 days, they get a 10% discount or a 5% discount. You don't get paid. And they're continuing to order product. You have to have someone, the salesman or whatever, monitoring. You don't want to let them get too far ahead of you. If they're getting too far ahead and they didn't make the payment, Again, it's the history you have with the client. If it's a new client, ultimately it may have to be COD. Now, you're going to send out, honestly, 60 days, they get a collection letter. And the collection letter with the invoice, some people put a red sticker on there. I really believe, because I've done collection letters on behalf of clients, no one in today's economy is really afraid of a collection letter or a lawyer's letter. I've really found that to be the case. Okay? They're afraid of suits, but that's down the road.
But now you called the person,
Right.
and they said, right now I just don't have it. So now you're going to follow up with a call or a letter the second time?
Well, if they tell me they don't have it.
The next question is going to be, well, when do you anticipate? When should I follow up with you, or would you?
Well,
would you
no.
say that?
I try to explain to them that I'm in business also, and you got to make a business decision. I can't afford to extend you any more credit. I can't afford to give you any more
Right.
product. I'm willing to work with you. Okay, if you want more product, I need you to pay off a little bit of the outstanding debt as well as for the new product. But again, that's a decision that you have to make.
No, but now let's say it's not about ordering new product. Now you called them and they said, listen, Mr. Hochler, I just don't have it. And you asked them, well, I need something today. And they said,
Right.
they say to you, let's say they say, well, I'm waiting on some checks from, let's say they get paid from the insurance industry, whatever industry there is. I'm waiting on some checks. I thought I would have it. Hopefully within the next 2 weeks I should have it. I'll be able to then pay you something, if not the whole thing. What's your response when they say
Well,
something?
the response, not of me, but of the collection person is, I appreciate your business circumstance. I also have a business circumstance. And if you can't give me anything now, I may have to take further measures. And you leave it open-ended. And then you make a decision depending on the balance. Again, before you get to me, before you get to a collection lawyer,
Right.
You're permitted to sue in Nassau and in the city of New York, and there are also courts outside of the city of New York, city courts, up to a case up to $5,000. That's called commercial claims. That's on behalf of the business. That's a small claims for business.
And you don't necessarily need a lawyer to do
You
that.
definitely don't need a lawyer.
Okay.
You go to the court, and there's a personal appearance part. Most of the courts are very nice. They're very helpful. They give you a booklet, and it's also a little cheaper. However, you have to go to court yourself. So depending on the balance involved, and speaking on behalf of myself, it's always good to consult with an attorney. If it's $500, $1,000, it's certainly not worth the attorney's time unless you have 100 cases.
Well, now, will you then, let's say you talk to them on the phone. Let's say the business owner or the person that works for the business, call them on the phone, didn't seem to get, would you follow that up with an email?
Well, what would happen is the bill must go out every month. There's a
Right.
legal cause of action called an account stated. An account stated is a bill that goes out,
Okay.
and if the customer doesn't refute it or doesn't dispute the debt, it's considered a valid debt.
How much time does the customer or the other business have to dispute the debt?
They can really dispute it at any time, but 30 days is a reasonable period of time. Under the Fair Debt and Collection Practices Act, when you're dealing with consumers,
Okay.
if you send out a demand letter, there's a 30-day proviso in there.
Okay, and if after the 30 days is it deemed that
It may be deemed valid, but, in court, again, depending on the economy, depending on the nature of the debt. Courts
Okay.
are, unfortunately, the reality is they're very sympathetic because of the bad economy to small businesses that do owe money.
Now, what about, what should they put in the letter? If it's not coming from an attorney now, you said you mail out the invoice.
Right.
Would you email it or just regular mail?
I think in today's world, regular mail may be discarded, and I also call this the case of two touches. If you send out a regular mail, email doesn't cost you; it's only time of your employee. Email's very effective; it's instantaneous, and it gives you two opportunities. The email today and the letter reaches in a day or two, so it's two opportunities. Most people, I really believe, are good. And if they're able to pay, they will. So you give another opportunity by the letter and the email.
You tag it so that you can mark that they received it, or?
I don't worry about that. I'm a big believer that if I sent it out, that's good enough. There's a legal concept where it's deemed received if you mail it.
Okay. So now, anything specific you would put in the bill now? This is a second. Please note it was due. Any specific language that you want to put,
Again,
or you would recommend?
honestly, I don't think the language, there are collection agencies and people take a very aggressive approach. My experience is
Which
that
they also should be careful because they can be sued too for
Absolutely.
harassment. And matter of fact, didn't the governor wants to put in New York State wants to put in different harassment laws from creditors and so forth and agencies that are that these.
How many people are watching this show? Well, again, now I believe the economy is improving, but the consumers are really protected to a great extent. In fact, there was just in Newsday, I think last week, with the foreclosure actions, the courts have taken a posture really against the banks and the lenders, and the cases take very long to get to court, and they take very long to come to a decision. And now they're dismissing cases for being beyond the statute of limitations. So the climate is really not on behalf of the institutions, not on behalf of the banks, not on behalf of the insurance companies. I'm in the pits, I'm in the courts every day, and the courts really will try to give the consumer and the small business person a break.
Okay.
So you have to be aware of that.
Well, and it's funny. You hear some of these people, these horror stories where, the company has this automatic call to the, they go 5 times a day, 6 times a day, and then and I have clients that they say to me, well, I told them, please stop doing it. They say, well, it's automatic. I can't,
Well, I actually was a collection manager. We had 50 collectors, and we had automatic dialing.
Right.
And again, with respect to consumer debt, you are not permitted to call beyond certain hours. You're not allowed to call certain times of the day, and you must speak to the debtor. This is only consumer debt. It's not business to business.
Now, how does it work with business?
Business, you can pretty much, the Fair Debt and Collection Practice Act, I don't believe applies. I'm pretty sure it only applies to consumers.
Now, how does it work? I've heard people say, you know what, if you don't pay me, I'm going to call your boss. I'm going to let your work know, your employer know.
Well, again, with respect to a consumer debt, you are not permitted to speak to anyone other than the debtor. In fact, under the federal law,
Right.
if you violate it, you're responsible for, I believe, up to $10,000 and legal fees. So some consumers, knowledgeable consumers, they take an aggressive posture. So for instance, if you make a phone call and you want to speak to Brett Harrison, and Brett Harrison's wife or child picks up the phone, you can't say, I'm from ABC Inc. and I'm calling about the money he owes. That's a violation. What you're permitted to say is, hi, this is Mr. Hochler, and I'd like to speak to Mr. Harrison. What's it about? It's a personal matter. That's all you're permitted to say. You're also not permitted to leave a message on the phone as to what it's about. You cannot leave that. That's a violation of the federal law as well. So with respect to consumers, you have to be very careful.
And you also, they're not allowed to fax something either, are they?
If it's a consumer debt, you can't, because you don't know who's picking it up on the other end.
Right. That's and have you seen, are there firms that just sue the debt, the one that's owed the money?
There was a firm about 5 or 6 years ago, he would advertise he had a shark. And
Right.
the nature of his practice was to go after unscrupulous attorneys and collection agencies. And there are people who don't do what they're supposed to do, and they should be stopped. But there are attorneys that make their living suing other attorneys for violations of the federal act.
And how much are those? Are those discretionary fines, or?
It's not a fine. It's in federal court, and it's up to $10,000 plus attorney's fees for each violation. So, for instance, if you left 5 messages, that's 5 violations. If you sent the consumer collection letters have to have certain language in it. If it doesn't have the right language in it, that's a violation. Also, the envelope if again you're dealing with a lawyer or a collection agency, not the judgment creditor,
Right.
can't say that it's from a law firm. It has to say personal and confidential, and just have an address.
You can't have your letterhead on the outside?
No, not if it's consumer debt, no.
Business debt, obviously.
Business debt's fine.
So that's a violation in itself.
That's
to
correct.
Consumer.
Again, the concept being it affects your standing with third parties.
It just seems like it's so overly burdensome to the business. And here they are just trying to collect a simple thing like an envelope.
Well, again, in today's politically correct world,
And that's a tough one, to politically correct.
yeah. Well, again, it should be a shield, but very often it's used as a sword.
Yeah. It seems like now it's like, well, at this point we might as well take a lot less so you don't have to be hassled.
Well, then stay off the phone. Don't send letters. Hire me, and I'll sue 'em.
Well, that's what's quicker.
Well, again, it has to be cost efficient.
So if you were going to recommend to businesses that are trying to collect from, we'll start with other businesses, what are the 3 or 4 or 5 things you'd recommend when they set up a relationship?
Absolutely good intake information. Get the correct legal composition. Ask them to provide you with a copy of the certificate of incorporation. Or get the name, and there's a website where you can check with the Department of State.
And where is that for New York, let's say?
It's, I think it's NY Department of State. You just type in New York State Corporations. There's a website.
And you can search names,
You
and
can
then
search
it'll
names,
say
right.
where they can officially be served, who are
That's correct.
the officers.
Right. Well, it may have an officer, it may not, but it'll give you the correct legal composition, and that's the most important thing. The second most important thing is their creditworthiness. Where did you get them from? You know, does it come from a good client? You know, is it a random phone call? So
How did you get them? Did you just get them from a website randomly, where on your advertisement, or did another business entity recommend them that you've had relationships
right,
with?
Right. It's it's always, it has to be a gut call. You can't do everything by computer.
Right. Well, Don, we are just about out of the half an hour, believe it or not. I told you it would go quickly. And there's a lot more to this. I know we're just giving basic ideas and basic concepts based on your years of experience. But the bottom line is you got to be careful. You got to be careful who you deal with. Do a little bit of research. Do a little background search, because the bottom line is you could make the sale, but you still may be out of business if you don't collect.
Right. The famous line is, it's not how much you make, it's how much you keep or how much you get.
Exactly. And you don't want to have to discount your services in order to get some type of payment. Once again, thanks again.
Thank
for
you.
listening to Legal Straight Talk. You can catch us at hlgny.com. Thank you again. Hochler.
Hi, I'm Jerry Parisi. Join Tom Neely and Tommy Marr right here on Cablevision Channel 20 each week for an interesting episode of
The Long Island View.